Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone. Welcome to the Appeals Court. We are, of course, holding argument via teleconference due to the ongoing pandemic. The rules for oral argument are the same as during live in-person arguments in our courthouse, which is to say it's 15 minutes per side with no rebuttal. I'm Justice Rubin. I'm joined today by Justices Neyman and Ditkoff. We will be hearing a single case, number 19-1063, Doe number 6969 versus the Sex Offender Registry Board. And we will hear first from Attorney Hernandez.
Good morning. Attorney Xiomara Hernandez for the plaintiff appellant John Doe. I'm here today requesting that the court find that the board abuses discretion by summarily denying my client's motion to vacate his classification hearing. The board, as you know, has authority to reconsider a classification hearing at any time. Here, I believe there is compelling reasons for the board to have opened this case again or looked at it again, as my client was deprived of his right to counsel. An offender is entitled.
Before you move on, am I correct that your client waited 13 years to seek to vacate the classification?
Yeah, so it was a long time, and he does admit to that. It was an extremely long time, actually. But he did, in my opinion, adequately explain why he waited so long. If you read on pages 31 and 66 of the record appendix, the hearing examiner did tell my client that he had the right to appeal the decision. However, he neglected to tell my client that he had 30 days. And unfortunately, my client's education level is not that high. So I think that he just didn't understand what was going on as well as that. And it wasn't until 2018 when he was at the Mass Treatment Center and overheard a conversation regarding being able to file a motion like that, that he immediately contacted CPCS and had an attorney appointed in order to file such a motion. But yes, I do admit that it's an extremely long time for him.
So the follow-up,
Okay.
if I may, Justice Rubin. So the follow-up is, at least the Superior Court judge, I think, found that there was a jurisdictional defect. Is that correct? And if it's not, why not?
Well, I'll just point you to the John Doe case number 20-9081, which is at 478 Mass 454, and it's footnote 1, where the court indicates that although there may be a jurisdictional issue, the appeals court does have the ability to look at the question whether or not the board abuses discretion in declining to reopen the hearing.
It seems to me you launched right into why you should have won before the board. But there are factual questions that haven't been developed on this record. And the Superior Court held that it lacked jurisdiction. If we conclude that this was an adjudicatory ruling on the motion, and therefore that there was jurisdiction in the appeals court, Superior Court, would we remand to the Superior Court for findings of fact, where we say your order is vacated, figure out what happened, and then determine this? Or would we remand back to the ultimately back to the board for fact findings, where, let's take, for example, the question of what was he told about having a right to counsel? What was the gravamen of what he filed asking for counsel? What is the significance or well, some of that's legal, but did he receive the notices that he allegedly was sent saying that he had to give more information before being appointed counsel and so on? Assuming those are relevant factual questions. Who examines them in the first instance under the procedure that you've gone through here, filing a motion in the SOR?
Yeah, I think that you would have the ability to remand that back to the board for them to make those factual findings. Again, when I didn't represent my client during the motion to vacate, so I wasn't able to gather any of those. I mean, I was left thinking, what's going on? There's so much information that's missing. And, I'm stuck with the record that we have, unfortunately, but he does indicate in the affidavit that he filed with his motion to vacate that he, doesn't recall receiving those papers. But I do agree, there's a lack of, a lot of factual information in here that I had a lot of questions about. I did ask my client about it, but, it doesn't matter because we're dealing with the record that we have in front of us. I mean, we do know for a fact that he did request an attorney, that he did file the necessary paperwork. We know that the board did require him to file certain documents and he didn't. Don't know why he didn't. Did he not receive it? Was he living with somebody else that maybe opened up his mail? What's his education level? Was he not able to understand what they were requesting? I do know that he thought in his mind that he was going to get an attorney. And I think those are facts that the board should have at least opened had a hearing to at least ask those questions. And they did it.
But all of those things, I'm sorry, Justice Ditkoff, you can go.
Counselor, your client's affidavit that was submitted, it contains two things that are plainly not true. One, that he was told just to sign. That's not what the transcript shows. And two, that his aunt was going to testify, where he specifically said at the hearing that his aunt was just there to drive and that he had a witness on some other thing that he couldn't get there. So in a criminal context, where there's even more protections, a judge can disbelieve a self-serving affidavit, especially when it contradicts the facts known to be. Why wasn't SORB allowed to disbelieve your client's affidavit under these circumstances?
Yeah, well, so in terms of the hearing transcript, that wasn't even included in the original record. I actually filed something requesting that it be included, and I paid to get the transcript because I was curious. He was slid a paper. That doesn't make sense. So he wasn't just slid a paper. He was told what the paper was, and he did sign it. But what the hearing examiner did not question my client about was, why did he request an attorney and then show up without one? And I think the hearing examiner could have received a lot of information had he done so. If you look at page 25 of the record appendix, they show up to the hearing and the hearing examiner says, okay, you're here without an attorney. That's on line 21. You're here without an attorney. And then my client says, yes. No further questioning. Why are you here without an attorney? I thought you wanted an attorney. And then if you turn to page 26 on line 13, the hearing examiner again asks him, or somewhat asks him about an attorney. He says, and now for whatever, you went back and forth with the Sex Offender Registry Board and you determined either not to be indigent or a lawyer was not appointed to represent you. I don't know the circumstances why. I think it was on the hearing examiner to find out the circumstances why, because it could very well be true that my client did think that one would be appointed for him. In regards to the aunt, this isn't part of the record, but from what I gathered from, because I asked him about that, because he did say during the hearing that his aunt was there to give him a ride. He claimed that before the hearing began to be recorded, that he told them that his aunt was there also to testify for a ride, but also to testify. And they told him that he couldn't testify because he did not abide by the discovery rules to have witnesses at the hearing.
At a SORB proceeding, if one isn't represented by counsel, do they ordinarily, I don't know if you know the answer to this, are they required to, and do they do the colloquy that we require in a criminal case to make sure that the waiver is voluntary and knowing?
Well, if you look at the decision I cited earlier, the 209081, that's 478 Mass 454. They do, although they didn't get to the issue whether or not this plaintiff was deprived of his right to counsel, they did talk to the board's counsel, who indicated that pursuant to the board's, this is on page 461, that pursuant to the board's current practice, when an offender attends his or her classification hearing without a counsel, the board engages in a colloquy with the offender to ensure that the offender is giving up his right to counsel knowingly, intelligently, freely, and voluntarily. That didn't happen here. He did sign the form. I'll admit he did sign the form. And again, his education level is pretty basic. So I'm
Well,
not
in a
sure.
criminal case, and again, I don't know 13 years or 15 years ago, whatever, but in a criminal case, signing the paper is some evidence, but it's not sufficient. You know,
Yes.
there has to be an oral colloquy with,
Yes.
doesn't specifically have to have any questions, but you have to be told certain things in substance, you know, about what you're giving up.
And I think that should be the same case here, to be honest with you. There should have been some sort of conversation between my client and the hearing examiner regarding why an attorney wasn't there. He requested one wasn't there, why? And if in fact he just didn't want one, he changed his mind, the hearing examiner could have gotten over the rights he's giving up by not having an attorney present.
Counselor, if the SOAR wound up reopening your client's classification, is there any reason that the examiner wouldn't be able to consider your client's subsequent guilty plea to indecent assault and battery in his current incarceration, or not incarceration, commitment as a sexually abused person?
So no, there's nothing barring the hearing examiner, if a new classification hearing were granted, from looking at those facts. No, absolutely not. They will absolutely look at those two things. So, and I would just end by saying that I do believe my client was prejudiced by not having an attorney. First, an attorney would have been able to follow the discovery rules and have multiple people testify at his hearing, specifically the aunt, the issue that happened with the aunt. And also, this wasn't in his affidavit, but an attorney could have been hired to file a motion for funds. My client's index crime was committed when he was 14 years old in 1983. And the hearing took place in 2005 when he was in his late 30s. In addition to that, an attorney could have more effectively argued that the index crime, which took place in 1983, was stale, and that the other conviction that happened in 2003 was a non-contact. It was open and gross conviction. And because of that, I request that this court find that the board abuses discretion in summarily denying my client's motion to vacate. They should have at least opened the hearing to gather more facts regarding what happened with his request for an attorney.
I just have one final question. And let me preface this by saying I do understand you are not counsel on the motion to vacate.
Yes.
In response to Justice Rubin's earlier question, you delineated a number of, let's call them holes in the record, questions that should be answered. But am I correct that it is, excuse me, am I correct that it is your client's burden on a motion to vacate to raise all of those things in affidavits and supporting documentation in the first instance? Everything you've raised here they're excellent arguments. But if they weren't raised before the Superior Court and before the hearing examiner, it's very difficult for us to consider those arguments for the first time in this venue.
Yeah, yes, I agree with you. That is difficult. The fact that there wasn't more contained in his affidavit. I wish there was more in there, because there is more to this case, and it's not part of the record, unfortunately.
Is there anything precluding you from I understand a lot of time's gone by and there's, but is there anything precluding you from filing another motion to vacate with all of those details that you represent to us do exist?
I don't think there is. I don't think there would, probably be denied again just because the amount of time that has passed. But yeah, I don't think there is anything precluding me from filing another motion to vacate.
Thank you.
And if there's no further questions, I will rest on my brief.
No further questions? Seeing none, thank you very much. Excellent argument. We will hear now from Councilor Shania.
I
have that wrong, Shania.
It's an old French name that nobody can pronounce, unfortunately. The board's position is that this case falls squarely within DOE 209081. It's the same exact fact pattern, other than 6 years in 209081 and 13 years here. And really what the court said in that case is the only thing you're looking at is, did the board abuse its discretion? And the hearing and the position the board has is we didn't abuse our discretion, and the Superior Court agrees with that.
Okay, can we take it step by step though?
Sure.
So what we have here is an appeal from a dismissal for lack of jurisdiction. not,
Correct.
not an affirmance on grounds of no abuse of discretion. So let's begin with that. Does the Superior Court have jurisdiction to hear this appeal?
No,
Why not?
because it wasn't an adjudicatory hearing.
What is denial? What is denial of a motion but an adjudicatory act? That's what courts do all day long.
No, because what has to be shown is that the adjudicatory proceeding was similar to an actual hearing where you have evidence, you have witnesses.
People file motions all day long. Motion for a continuance, Your Honor, denied, and they appeal, right? In a court all day long, no hearing, no evidence, no nothing. Motion to file an overlength brief, denied, and they appeal.
But we're discussing, the administrative agencies are confined to 30A rules. The 30A rules specifically say it has to be an adjudicatory hearing, and it's defined by case law as a hearing that involves the similarities of a trial or
but somebody
evidentiary hearing.
The motion was not. You didn't say we all we're allowed to do is adjudicatory hearings. We don't know what this motion is. So we put it in the trash or we sent it back. There's someone has handwritten on it a ruling with substantive reasons. And then I don't know, I can't really read it. There's a stamp and a signature. It seems like the board adjudicated that this motion was a loser based on waiver. Is that right?
Well, again, the board has the burden. Well, they have the burden of proving that not opening the hearing would be a miscarriage of justice. The Superior Court had the authority to look at whether or not the hearing examiner abused that discretion that miscarriage of justice.
So they had jurisdiction
just for that issue.
All right. Now you say abuse of discretion. I'm going to say probably, although I haven't looked very deeply into this. Ordinarily, the what's actually reviewed is abuse of discretion or other error of law, right? An error of law would be an abuse of discretion.
But the case law for these reopening an agency decision, you also have to show a substantial miscarriage of justice. You're trying to prevent a substantial
no, that may well be. There may be prejudice. I don't know the ins and outs of it all. But all I'm saying is, because it seemed to me when I looked at this, I thought, I don't know if this is a winner or a loser, but I think there's jurisdiction at least to review the appeal for abuse of discretion, review what happened for abuse of discretion.
Right. That's what the Supreme Court said in 209081. The review is limited to. It's not limited on the facts of the case, whether or not the first classification was properly made, whether or not the individual was prejudiced by it, by the prior hearing. The limitation is, did the board abuse its discretion, and did a substantial miscarriage of justice occur because of that abuse of discretion?
And is it your view that a petitioner can bring a motion like this? I don't say they'll win, but they can bring it at any time.
They can bring it at any time, but again, the burden is on them to show that failure to give the waiver would be a miscarriage of justice.
Now, if we find, I'm sorry, go ahead, Judge.
Counselor, in Doe 209081 in note 6, the SJC specifically says that review of a motion this should not be decided on a motion to dismiss, but instead should have a motion for judgment of pleadings. And 7 months after that opinion came out, your predecessor in this case filed a motion to dismiss, which the Superior Court judge allowed. Is this because SORB does not accept this law from the SJC, wants it reconsidered, or is this just an error or miscommunication?
I do know, and this is one of the, there's a separation between legal and hearings. So I don't know when hearings receive this, they don't confer with legal to say, how should we rule on this motion? They make their own rulings. So I don't know what the hearing examiner or the board member, when they denied the motion, were thinking, or their rationale, or whether they were even aware of Doe 209081.
I'm asking why when you get to the Superior Court, is there a motion to dismiss, which is exactly what the SJC said shouldn't happen?
Well, the motion to dismiss was based on the lack of jurisdiction. I mean, again, the judge, we were arguing that it was an adjudicatory hearing and there was no abuse of discretion. So we were asking that it be dismissed.
I get that, but the SJC specifically said you shouldn't move to dismiss. You should instead move for judgment on the pleadings. So I'm trying to understand whether this Superior Court motion is because SORB does not accept this law or wants it overturned, or because it was an error. Is that what's happening still? Is we still getting motions to dismiss each time on one of these, contrary to what the SJC case says?
Well, first of all, I didn't handle this case down below, so I don't know the rationale for bringing why that attorney brought the motion. I don't know. I haven't had one of these cases since this case, so I haven't had the opportunity to file a motion to dismiss or decide whether I would file a motion to dismiss. So I don't know the answer to that because right now I don't know what the rest of the office is doing. I personally have not filed any motions to dismiss on these cases. I usually just go in and argue the fact that there was no abuse of discretion and that there was no miscarriage of justice. Because again, the limitation is it should be discussed as to whether or not there was an abuse of discretion, not whether or not the initial classification was valid.
Can the offender move to redetermine? I note your regulation says that if the offender is incarcerated, 803 CMR 131-2E, that he can't move for redetermination. Does his current situation as an SDP committee count as incarcerated for that regulation?
I don't believe it does. I don't know that it would consider to be incarcerated, but even under the regulation we have, the individual has a right to file for a reclassification.
But a reclassification requires changed circumstance, right? What he's asking for here is a vacatur and rehearing of his original, obviously it would be with current evidence, but of his original hearing, right? We don't know. He doesn't say anything about changed circumstance. He just says he didn't have the lawyer he was entitled to.
Correct. If he, again, the changed circumstance is such a low bar that the board is using. The fact that if he's in treatment is enough to bring it forward as a reclassification action. It's not like we have a high bar that they have to get over to have a reclassification hearing. We have reclassification hearings now just on offenders saying that it's been, I've been classified for 10 years. I haven't been in trouble in 10 years. And we'd like a reclassification. That's been deemed sufficient offense-free time in the community in excess of a certain period of time. So the bar is not high to get the reclassification. And once the reclassification starts, obviously, the board has approved by clear and convincing evidence the current risk and danger. At that hearing, this individual would be able to bring in any information they have as to their current circumstances.
You know, when SORB affirmatively moves to redetermine, here you have an offender who's committed another sexual offense and is SDP committed. Would it be SORB's regular practice to move to redetermine when he gets out, or is it sort of case by case? There's no practice.
Well, under the new rules, and again, we've got a case pending in the SJC right now about classifying individuals while they're incarcerated. The new rule that we have is that if someone is classified, in this case is pre-classified before this ruling, if we classify them with no parole date in sight, their classification is provisional and there's no dissemination, and they have a right to bring in more information prior to their release for us to reassess their risk and danger at time of release. Or if it's a short enough sentence, we try to classify them within 6 to 8 months of their release date so that it's current information. So that's pretty much the policy that we're using right now. The case we have in the SJC is someone who waived their classification hearing back in 2005, is filed for to vacate and to stop dissemination on them and classification at this time, because they don't have a parole date in sight. And that's going to be heard probably, I think that's going to be heard in February.
You don't have a case number for that case, do you?
I can provide it to the court. I don't have it off the top of my head. I think the amicus briefs went out on it a month ago. I know they're kind of fast tracking the case. I have a feeling what the court's going to rule is that just because someone waived their hearing does not prevent them from being put in provisional status. I think that's going to be the result of the case.
Can I ask you a question about this case? So I take it both the Superior Court and we are entitled to review for abuse of discretion. The reasoning given by the board in denying the motion was that the petitioner formally waived his right to counsel. That's what the one clause that describes the merits says on the order. If we conclude that merely signing a waiver of counsel form is inadequate, do we vacate and remand because it's an abuse of discretion?
No, because 209081 has the same exact fact pattern. And again, you're basing this on policies and procedures the board used at one time that are no longer being used. And the 209081 still said you still have to show not only there was an abuse of discretion, but that the individual was prejudiced by that.
But you didn't reach the question of, or the board didn't reach the question of consequence of prejudice. It just said formally waived, no error. And what I'm saying is, and I may be wrong about this, it would surprise me, it may have been 15 years ago, I don't know, and then I don't know what we do if the current law is different and so on, but it would surprise me if merely signing one of those forms was a valid waiver, a knowing and voluntary waiver of the right to counsel. I'm not saying he didn't waive his right to counsel, I'm just saying that may not be good enough. And
well, the case in 209081 is specific that the individual at the hearing argued back and forth that he wanted a lawyer, and he kind of got browbeat into signing it. And the court, even in that case, said that because that was, back then, and he can't show that he was actually prejudiced by that procedural due process.
But we're not going to look at prejudice. I mean, I guess we could affirm on any ground, but I don't think we're going to look at prejudice in the first instance. Here, we don't, I mean, that's for the board to figure out. The motion was filed before you guys.
Well, no, it's not for the board to figure out. It's for the offender to establish.
Yes, I agree. Yes, I agree with that.
So the board doesn't have to figure out whether he was prejudiced.
But we don't know if you credit or discredit his affidavit, right? We don't know anything. It didn't go that far.
Because it didn't have to. The board denied the motion based on the fact that he didn't present the information that would require the board to reopen the hearing.
Well, okay.
Counselor, when you argued 209081 back in 2017, you represented to the SJC that SORB's current practice is to engage in a colloquy with the offender. And if the offender at some point says, wait a second, seeing what's happening, I want counsel, to stop and continue it. Is that still the practice today?
That is the practice. In fact, I usually I think 2 weeks ago, I had a hearing where they were not represented. It was a reclassification that they brought. And what I explained to them is the seriousness of their case, what could or might not happen. I explained to them they have the right to an attorney at any time. And then I also explained to them that if during the hearing they change their mind and they'd like an attorney, we will stop the hearing. I explained to them if they can't afford an attorney, we will give them time to apply for an attorney. I also tell them that we would postpone the hearing for them to make that application. And then I have them go on the record and say, I go through the whole colloquy, just like in a criminal case. I ask them if they had any drugs or alcohols or anything that would cause them not to understand what they were doing. Is it their intent to go forward without an attorney? Do they understand they have an attorney and that one can be appointed to them, or that they could postpone to get their own attorney? So we go through the whole process with them.
Did
And
any
I'm
of
very
that
strict about
happen? I'm sorry to interrupt you, Attorney Shania. Did any of that happen in the present case, or do we just not know what happened in the present case?
I am guessing in the present case, it didn't happen because it was before this whole idea with the board being an administrative agency. They weren't, the policy I think they were using was not as strict as it is today about the knowing and intelligent waiver of an attorney. I mean, one of the things that the 209081 did is it alerted the board that we do have a problem with that issue. And although the 209081 isn't applied retroactively, we have since that time changed our policies to try to fit, to make sure that everyone who goes without an attorney has a knowing and intelligent waiver, and that we've made it clear on the record that they can stop the hearing at any time to go to either apply for an attorney or to hire their own attorney. So the board is trying to follow that policy and trying to make it more clear on the record, especially that these are knowing and intelligent waivers of attorney.
Your time has expired. I have one quick question. You say 209081 does not apply retroactively. Is there a holding to that effect? Is there a case that says that?
No, well, the court itself did not specifically say this would be retroactive. In fact, they really didn't discuss the knowing and intelligent waiver. They accepted my assertion that that's what we're doing. And they outlined what I had said to them and said this would be good practice.
Okay.
They didn't say we had to. They said it would be good practice, and the board is following that practice.
Okay. Your time has expired
Thank
unless
you.
there are other questions from the panel. Seeing none, thank you both for excellent arguments. An interesting
Thank you.
case.
Thank you.
It is submitted. And with that concludes our session for today. Thank you all.
Thank you.
Thank you.
Take care.